Hey everyone, this is Eddie and welcome to a review of Performance Test B of the California Bar Exam that was administered in February of 2017. And let's get right to it. I'm going to refer here to my notes. So some basic things about performance tests, and I have these in mind because I always use them. So you do want to apply your prior knowledge, and you want to deal with obstacles and perform your analysis, and I'll get into that. I'll get more into how this applies to this particular exam, and I'm also going to mention some noteworthy items. So I am going to try to move rather quickly here because of course this covers 3 hours, so we're going to try to do it in a reasonable time. All right, so let's talk first about applying prior knowledge. So when I first saw this, I said, okay, well, you have an imperfect contract or some kind of an unenforceable contract, quantum meruit. So that usually implied in law contracts. And I did talk about that in February. I believe it was early February 11. I talked about this concept here tricks a lot of students. A lot of students get confused. And but hopefully you understood it. But the point here is that you do want to apply your prior knowledge just to understand the basics of the question. And of course, we did have an issue where a court said that it was an unenforceable contract and quantum meruit and all that. But we'll get more into that later. So let's see now. Perform your analysis. Okay, so also here you did have a counter argument, what I call Hunter's counter argument, and that of course was that one case, Harum versus Vanderbilt, and I'll discuss more of that in a bit. And of course you had to perform your rebuttal, so hopefully most of you guys did that. And of course there were more issues out there, but I think these right here were the important issues that you had to tackle. Okay, other unique characteristics of this particular performance test was that they asked you to not write the facts. All right, so when they say that, it's like, okay, goodness, what's going to happen here? So they're going to have extensive rules or facts you don't know, so just be careful. And also, I did have to make up headings, and that's always a good idea when you have many issues, and then you can apply time and techniques. So let's see. So of course, caption, I'm gonna get too much into that. So the task, let's see what the tasks were. Let's go to the actual exam. Instructions, here it is. Whether the city is immune from Blanchard's claim for quantum meruit. So let's go ahead and begin the discussion. So whether the city is immune, so plaintiff is not barred from recovering solely because it is a municipality. So we have that right away. And the analysis, of course, here you are dealing with a private party suing the city, or a potential lawsuit against a city of Corson, and power to contract on subject matter. Okay, so here we have the case Lyman. There was a lot of rules coming from that particular case. So a municipality is subject to quantum, and I just put QM instead of I was writing quantum meruit, provided that the city has the power to contract on that subject matter. So, and also of course, if there is no contract, or where an express contract is invalid, then of course you get into the area of mere irregularities. And there in Lyman, of course, we had a woman there, right? And she never entered into a formal contract with the city. Okay, so let's keep going. And but the point here is that it falls within the type of contract that the municipality has the power to make. And let's go into the analysis. Again, here I just used an analysis because it was just a lot coming in, and it made it a lot easier for me to just structure this and organize it. But of course this is not needed, but if it helps, add it. Also, when you're dealing with so many rules, if you want to highlight the rules, that's perfectly well as well. The examiners are concerned with your analysis, not so much how beautiful your written work is. And of course, if you go to bar essays and you looked at the PTs that did not receive a passing score, and then you see many beautiful return work that is very organized, because the examinee spent a lot of time organizing, preparing, making it look beautiful, but here they're concerned more with your analysis. So even if you have an extra heading, or if you have words that are in bold, doesn't matter, just do your analysis. Okay, so here, of course, the city contracted with Mr. Blanchard to upgrade the water treatment. So there seems to be no dispute about that. And also the Mayor Reyes, no relation here, okay? She says that the private market will not get involved. So it does seem that the city did have the proper subject matter. So that is met. Now let's keep going. Now here's where we have now the imperfect contract. And then of course we get into that issue, that ultra virus issue. Okay, that's coming. So imperfect contract, okay. And of course they do in the rules, they do give you the requirements for the city to enter into a formal agreement. It has to be in writing, all that good stuff. And let's talk now a little bit more about that analysis. So talked about the city attorney, how he signed it. However, there was no formal vote, right? And there was no entry in the council journal. So there's an irregularity, okay. But of course, we look at Lyman, and they say that that's the Supreme Court case of that state, and mere irregularities are fine. Okay, that's what they're saying. And let's see now, let's keep going. Imperfect contract. Okay, but here's a little area here where you could have gotten your points to give you assurance that he did great on this. Okay, so you have Hiram, right? And then what Hiram is saying, they're providing that counter argument, and they're saying that irregularities will get into the area of a contract being ultra virus. And then if that happens, of course, the contract is null. And so you have to definitely discuss that. And so you throw it in, and then of course that however is the rebuttal to the counter argument. And you can say that, hey, Hiram's appellate court case, and it goes against Lyman, which is the state Supreme Court case. And also in Lyman, we had irregularities that did not shield the municipality from liability. Of course, we already mentioned that. So you must state how a court in that jurisdiction must adhere to the ruling in Lyman. It must adhere to it, because that's the controlling law. And also in Lyman, you had a situation where you had two parties that they never entered into a contract, and that court never classified that act as being ultra virus. So let's go ahead and go to that. So in other words, that was mere irregularities. That's what it goes to show. So lack of quorum, also mere irregularities. And also in Hiram, you also had the dissent, and you could say that that's not controlling, but it's definitely persuasive. So it suggests, all that suggests that where there is no formal vote, you're not going to go into the area of ultra virus. That's what it's saying. So the conclusion there is that the city will not enjoy immunity from Blanchard's liability claim. And this also is subject to the discussion of the function being government in nature, or it being proprietary in nature. So let's go to that now. So let's go right away into government in nature. And of course you have the health, safety, and welfare elements there. And of course I want to say that this, if you're arguing on behalf of the city, you want to say that it falls under the area of government in nature. And in fact, you can make a very compelling argument, because water plan does seem to fall under that. Okay, so let's take a look at it. So of course, in this experiencing population growth, and there's also a dire need, and also it has the regulatory agencies, the EPA and the state version of the EPA there applying some pressure. So that sounds like it does fall under the area of government in nature, that it does fall under that function. Now, you do have other law here, okay? So, however, so put your brakes there, all right? So they do give you areas where those actions of the city might fall under proprietary in nature under that category. So there was 3 of them. Let's go to the one in Lyman where the city operates a water plant. So if I meet that element, then I need not go into the other elements. That's going to save me a lot of time. Does the city operate a water plant? And that determination was not difficult to be met. So I'm not going to get into that because there was plenty of facts that says that it does. And so it does seem as if the city is operating under a proprietary function. Okay, so now let's keep going. Now, I want to know next, and notice the headline, does immunity against a quantum error suit apply where a proprietary function is present? And of course, we have Galax there, and we have Reckitt. And of course, this is the city, as we stated above. Okay, so the city can be held liable under Blanchard's quantum merit suit. Now, let's go on to question number 2. Whether Blanchard can actually prove its claim for quantum merit. And I think once you get to this point, and I think that the discussion is not so heavy, so you can relax a little bit here, and they do give you the elements there. So I did end up combining the first element there and the second one. I did end up combining them. So instead of having 4, I ended up with 3 elements. So services and materials furnished to the city. And of course, that was there were facts to support that. There were 2 meetings, one between Mr. Blanchard and the mayor, and one with Mr. Blanchard in front of the city council. Okay, so that's going to be easy to prove, and I'm not going to get too much into that. And of course, that invoice that shows that Mr. Blanchard and his company substantially or completely performed their duties. So that element is met, services and materials accepted by the city. Okay, again, those 2 meetings, the mayor and the city council, you can easily go through that. And Blanchard's notifications to the city of expectation to be paid. And of course, again, those 2 meetings, and it was projected that it would be an amount of $210,000. And the conclusion for that Mr. Blanchard and his company will probably prevail on that claim. Issue number 3. Let's go right down to this. It says how a court might go about evaluating damages if Blanchard were to recover under a quantum merit suit. Okay, and that, of course, you look at the invoice and the services they provided, and that wasn't difficult to make. I think at this point, you just kind of want to finish up, and time here becomes an issue, right? And of course, stated conclusion. Of course, they would recover. Blanchard, his company, would recover. And the conclusion, it's better for the city to settle. So I hope this helps. Hope everyone watching this passes, and wish everyone best of luck. Until soon.